So you're thinking about buying a brand new home in Arizona. It's super exciting for sure, but it can also feel a little like navigating the Wild West. Today, we are going to dive into the single most important rule that's designed to protect you, the home buyer. We'll show you how to use it to spot those big red flags before you even think about signing on that dotted line.
You know, to really get why today's protections are so strong, we've actually got to take a look back. Because Arizona's real estate history, well, it wasn't always so buttoned up. In fact, it's that history that made today's strict rules absolutely essential.
And yeah, this quote right here, it really says it all. The state went through these periods where developers were making promises they just couldn't keep, and it left buyers with a whole lot of problems. This speculative excess led directly to the state creating a really strong framework to make sure that kind of consumer harm wouldn't happen again. So, how did the state clean things up? Well, they created one single, powerful document that every single developer has to have before they can sell you anything. You could think of it like the new sheriff in town, whose whole job is to bring law and order to the world of new construction. It's called the Subdivision Public Report. And the key phrase to lock onto here is Consumer Protection Document. This is not the state endorsing the project or saying it's a good investment. Nope, it's the state providing you with a verified background check to make sure that everything the developer is telling you is actually true.
Okay, so this right here, this is the one rule to burn into your memory. It is absolutely 100% unlawful for a developer to offer to sell or lease you a lot in a new subdivision without first getting this public report from the state. No exceptions. Well, almost no exceptions, but we'll get to that in a sec.
And what kind of juicy details are inside this report? All the critical stuff. It verifies things like the condition of the title, that you'll actually have utilities like water and power, and that there's permanent legal access to your property. It also confirms any restrictions or claims on the land, what they call encumbrances, so you don't get any nasty surprises down the road.
And this is where you get some serious power as a buyer. If a developer breaks that golden rule and sells you a property without giving you the public report first, the law gives you this incredible remedy. You have up to 3 years to cancel the contract and get your money back. That's how seriously the state takes this.
Now, remember how I said almost no exceptions? Well, while that main rule is incredibly strict, the law does get that developers need a way to gauge interest in a project, so it created 2 very highly controlled exceptions that let them test the waters with potential buyers before the final public report is issued.
The most common one you'll see is called the lot reservation. And let me be super clear about this. This is not a sales contract. You are not buying the property. You're just putting down a small, fully refundable deposit to basically hold your place in line while the developer gets all their official approvals sorted out.
And you better believe this whole process is meticulously regulated to protect you. First, the developer has to notify the Arizona Department of Real Estate, or ADRE. Second, they can only take a limited deposit. Your money has to be held by a neutral third party, like an escrow company, not in the developer's pocket. And most importantly, you can cancel for any reason at any time before you sign a real purchase contract.
And that deposit limit? It's $5,000. That's it. If a developer asks for more than $5,000 before that public report is issued, that is a massive flashing red flag.
Now there is a second, much less common exception, the conditional sale. As you can see here, the key difference really boils down to commitment. A reservation is non-binding, and your deposit is totally refundable. A conditional sale, on the other hand, is a binding contract that only moves forward once the public report is issued. It's a much, much more serious step.
Okay, so let's say the developer's done everything right. They've cleared all the hurdles, and that public report is finally issued. Now what? Well, now the real marketing can begin. But a whole new set of rules kicks in to keep all the advertising honest.
And the law here is basically all about one thing: truthfulness. Everything in an ad has to match what's in the public report. They can't lie, and they can't leave out important facts. If they show a picture of some gorgeous community pool that hasn't even been built yet, it must be labeled artist's conception. And no more showing a 5-minute drive to the lake when it's actually 30 miles of bumpy dirt roads. Okay, so now that you know the rules of the game, let's put that knowledge to the test. It's time for you to be your own deputy and learn how to spot the outlaws in some real-world advertising scenarios. So picture this. You're driving down the highway and you see a billboard for a new development. Based on everything we've just covered, do you think you can tell if the developer is playing by the rules? Let's look at a couple of examples.
All right, here's the first one. It says luxury lots for sale. You see that? If that public report hasn't been issued yet, this ad is, no question, 100% illegal. It's an unconditional offer to sell, and that smashes the golden rule we talked about. This is a major, major red flag.
But now check this one out. It says, now accepting lot reservations, and, this is the key part, it includes that crucial disclaimer that the state has not yet inspected or approved the project. This is the legal way to do it. That little disclaimer transforms it from an illegal offer into a totally compliant invitation to just reserve a spot.
And look, we're not talking about a slap on the wrist here. The stakes for breaking these rules are incredibly high. We're talking about real estate agents losing their licenses, and the developer could even be looking at felony charges. It really shows you just how vital these consumer protections are.
So after all of this, what's the one thing it all boils down to? It's the single most powerful question you can ask when you walk into a new sales office. May I see a copy of the Subdivision public report? Their answer, and whether they can actually produce that document, will tell you everything you need to know about whether you're in safe hands.